Hello and welcome to the 2TG Employment Monthly webinar for May 2022. My name is Sam Stevens and I will be providing an update on arranging evidence by video conference of a witness outside of the jurisdiction. Evidence by video has become the bread and butter of both the courts and the Employment Tribunal. CVP or Teams hearings with the judge, counsel, solicitors and a number of witnesses at wildly different parts of the country is part of ordinary practice. The majority of employment cases will involve witnesses based within the UK. However, practitioners must be prepared to deal with witnesses who are based abroad. This may be a respondent's employee based at a head office in another country, a claimant who has left the UK following employment, or increasingly, witnesses who are based abroad taking advantage of the options of working from home, wherever home may be. The procedure for dealing with evidence by video conference overseas in the civil courts has been dealt with by way of a practice direction for many years. However, this issue is a hot topic in the tribunal because of new guidance issued by the presidents of the employment tribunals on the 27th of April 2022. In this talk, I will first explain the issues that arise on arranging video evidence taken from another jurisdiction. I'll then summarise the position in the civil courts, which is helpful for background and also useful for those employment claims pursued outside of the tribunal. Finally, I will turn to the new guidance that has been issued for the employment tribunal. But this talk will not cover other methods of seeking to obtain evidence, such as by letters of request. Let's look then at the basic issues that can arise when taking evidence from abroad by video link. It seems unusual that it will cause an issue because, to the best of my knowledge at least, a witness in the UK can voluntarily provide evidence by video link in proceedings abroad. However, not all countries have the same approach. Japan, for example, is often used in textbooks as an example of a country that does not allow evidence to be taken by a foreign court by video link. And I'm aware from my own practice that countries such as Germany and Poland have restrictions on evidence by video link in foreign proceedings. One reason for the objection to video evidence in those circumstances is that some countries see it as a foreign power interfering with their sovereignty. The prime reason given by the UK for the UK court's caution in taking evidence from abroad is to avoid a diplomatic incident. In other words, to avoid the UK being seen to have encroached the sovereignty of a foreign power and leading to a diplomatic objection. However, in my view, there are plenty of other reasons to exercise caution. Firstly, as a matter of comity, to respect other judicial systems. And secondly, to avoid placing persons in jeopardy by breaching foreign law. Let's turn then to look at how the civil courts deal with it and the relevant guidance. The starting point is Annex 3 of Practice Direction 32. This sets out guidance for video conferencing generally in trials, based on a protocol used by the Federal Court of Australia. Broadly speaking, permission is needed to give evidence by way of video conference, and there are additional hurdles where the witness seeks to give evidence from abroad. Unsurprisingly, the practice direction places the onus of seeking permission for video evidence on the party that seeks to call the witness. Paragraph 4 of the Annex makes it clear that there is no presumption that a foreign government is willing for witnesses to be examined in its jurisdiction. In my view, any party seeking to call a witness via video link from abroad needs to satisfy itself and the court that the foreign state doesn't object to it and that it's lawful to do so. And that seems pretty clear from Annex 3. Some cases may be clear. For example, that the White Book reports that the US Department of State has sent a letter to the senior master in 2011 stating that an English court could take evidence by video link from the US of a British witness without further permission. But some cases will be more difficult. Annex 3 advises the calling party to contact the Foreign, Commonwealth and Development Office, referred to as the FCDO. In particular, It advises parties to contact the Service of Process Department on SOP inquiries at fco.gov.uk. The SCDO should be able to assist with whether there are legal or diplomatic hurdles to arranging for evidence to be given by video from the foreign state. However, time pressures or uncertainty can lead to a court to ask parties to file and serve expert evidence on the law of a foreign state relating to video evidence. And this is what happened in the case of Interdigital Technology Corporation and others, and Lenovo Group Limited and others. In that case, the High Court had to consider whether it was necessary only to allow an expert to give evidence from Germany on the condition that the German court itself gave permission for the evidence to be given by video link. The interesting part of this decision was that the judge separated two distinct judicial processes. First, there were findings of fact to be made on foreign law, which were to be made on the balance of probabilities, namely, what is the law of Germany on this issue? And secondly, there was the judicial discretion that needed to be exercised as to whether or not to allow witness evidence to be given by video link from a foreign state with or without conditions. The judge directed himself that if the expert evidence showed that there was a significant risk that the taking of evidence would breach German law, that would weigh heavily in the exercise of discretion as to whether to allow video conferencing from abroad. In this case, the judge found that there was such a significant risk that the taking of evidence would only be lawful if the German court itself gave permission. Accordingly, the judge approved evidence by video link, but only on the condition that the party sought permission and gained permission from the German court first. That deals with the formalities on whether permission is needed, but one aspect that can often be overlooked in civil claims concerns the taking of oaths or affirmations. Paragraph 16 of Annex 3 provides that some countries may allow video evidence to be taken, but that the oath or affirmation must comply with local customs. The same paragraph creates an obligation on the party seeking to call the witness to make all appropriate prior inquiries regarding oaths and affirmations in the foreign state, and also be prepared to inform the court of the nature and extent of those inquiries and whatever findings were in fact made. Let's turn then to timing of these matters, and this primarily is dealt with by way of a practice note issued by the Chancellor of the High Court for the Business and Property Courts on the 11th of May 2021. And that stated that the parties had to have permissions in place basically for video evidence by the time of the PTR, or if no PTR is listed, the date for submission of the pre-trial checklist. So any inquiries that needed to be made with the SCDO needed to be completed by then. And the White Book, the editors of the White Book, have sensibly suggested that that should be taken as a good rule of thumb to apply in all civil courts. However, they emphasise that that should be seen as a long stop. The process for confirming whether permission is needed can be lengthy, and there must be time left for alternative arrangements to be made if a simple video link is not possible. The Chancery Guide in particular states that permission should be sought as early as possible in proceedings, which in my view is the most sensible approach. Basically start seeking to find out whether permission is needed as soon as possible. Let's turn then to the Employment Tribunal, and the best starting point is actually not with the Employment Tribunal, but with the Upper Tribunal and its decision in Secretary of State for the Home Department and Agbabiaka. The reason for that is the presidents have said that it's that decision that has led to the recent presidential guidance. The facts of the case are not relevant, but it's important to note that the Upper Tribunal treated this as an opportunity to give guidance on video evidence from abroad. The first issue that arose was whether giving submissions alone would require permission similar to or release inquiries for permission, similar to with oral evidence. And the FCDO's evidence was that it did not consider mere submissions to be problematic. And the upper tribunal held that that was determinative, because the Secretary of State alone was responsible for what may cause diplomatic upset or objection. I have to say that conclusion surprised me somewhat, because whilst the diplomacy side of things can be seen to be laying with the Secretary of State, in my experience, civil courts would likely want to take into account whether a foreign state would consider giving submissions to be unlawful, and it would take that into account in determining whether to allow video evidence. In any event, the upper tribunal noted the difficulty in distinguishing between evidence and submissions, particularly in immigration cases, where there are litigants in person, and advised caution on the part of the tribunal in determining whether or not permission or it should be sought, or at least inquiring whether permission is required. The second issue, which is very important for the employment aspect, is what procedure should be followed to determine whether permission was required for video link. And the upper tribunal, in the judgment, said that it had previously used the service of process address in accordance with Annex 3 of Practice Direction 32. So it followed the civil courts, basically. However, the FCDO, in its evidence in the case, frankly admitted that it had previously given erroneous advice on this basis, because the advice given to the upper tribunal was based on whether permission was required in civil and commercial proceedings rather than for administrative tribunals. And so the FCDO, in its evidence, said that it was setting up a new evidence team called the Taking of Evidence Unit, which would deal with requests from the upper tribunal. We then get to the joint presidential guidance, which, as I say, arose from the decision in Agbabiaka, and it prompted to make changes. The guidance at paragraph 10 notes that the FCDO had set up the Taking of Evidence Unit and that it was running from the 29th of November 2021. Importantly, it states that the employment tribunals will use the Taking of Evidence Unit service to determine whether permission is required for evidence to be taken from a foreign state. The .gov website at the minute, I think, is unclear on whether it is envisaged that the Taking of Evidence Unit will be used for courts as well as tribunals. It would certainly seem to make sense for it to do so. However, Annex 3 to Practice Direction 32 remains unchanged and does not refer to the Taking of Evidence Unit, but to the Service of Process Unit. Getting back to the guidance, the presidential guidance, it provides that essentially a party who is seeking to call a witness from abroad should email the tribunal stating it seeks to do so, and also to state the case number, the dates of any listed hearings, and the state from whose territory the witness intended to be called would give oral evidence. The tribunal will then contact the Taking of Evidence Unit on behalf of the party. And the SCDO's evidence in Agbabiaka says that the Taking of Evidence Unit will then check whether the foreign state, well, firstly, it will check whether it has any up-to-date information on that state. But second, if it hasn't got any up-to-date information, it will make diplomatic requests to determine whether the state has a law in place that restricts the giving of evidence, or if there is no such law, whether the state has a diplomatic objection to the taking of evidence by video link. It's proposed that the SCDO will keep an up-to-date list of previous responses, which should be published in due course and may lead to change presidential guidance when that happens. The FCDO charge £150 to the requesting party normally if it doesn't have the information on its database about another state, and it needs to make diplomatic inquiries. However, the joint presidential guidance has confirmed that HMCTS will pay those fees for employment tribunal requests. It's important to stress that this is merely an administrative process. It's to see whether or not permission is needed. The tribunal will still, in due course, have to make a decision on whether it will allow evidence to be given by way of video link. And there doesn't yet appear to be a settled view in the tribunal on what would happen in the rare but possible case that a country simply doesn't respond to the FCDO, and it's unclear whether or not there are any legal issues or any diplomatic ones to having the evidence be called by way of video. So what are the practical considerations arising from the new guidance? Well, I think the first thing is it's important to determine as soon as possible whether it will be necessary to call a witness from abroad. And my advice would be to try to determine that as soon as filing the ET1 or ET3. And if a part of a case is unclear and it's unclear whether you need to meet a certain part of someone's case and call a witness to meet that, I would recommend putting in requests for further information as soon as possible, so you can come to a view on whether you will need to actually call a witness based abroad in order to meet a certain aspect of that case. As soon as you know whether a witness from abroad is needed, best to contact the tribunal and start the process for seeing if there are objections by the foreign state as soon as possible. It will be most helpful to have the information from the FCDO before the first preliminary hearing, so that all matters of video evidence, etc., can be dealt with together without avoiding unnecessary future hearings. And importantly, this will allow a good time to consider matters if the information from the FCDO is that it's not possible to lawfully deliver the evidence by way of video. Because there are a number of alternative options to consider that can be considered at that first preliminary hearing. First, whether the witness can get to the UK on a specific date, which would then enable listing considerations to be made. Secondly, whether the witness can get to another jurisdiction where evidence may be more easily given. So it may be if someone's in a country very far away, but the country borders one which video evidence can be given. They may simply be able to go to that country for the purpose of doing that. Another one is to consider whether a different witness may be able to give evidence on, say, the same issue. For example, if you wanted to call witness A, but they lived in a country where it was not possible to give video evidence, you may openly say, well, we'll call witness B instead for cost purposes. And having the reasoning for doing so recorded can be helpful to avoid any submissions on adverse inferences later. And finally, the presidential guidance also suggests that the tribunal could consider evidence and by way of written evidence alone, including questions, which it takes a view would not encroach on any issues that arise from the giving of oral evidence. So all those matters can be considered together. And as I say, it will be cost effective to discuss this at the first preliminary hearing. And finally, I would always recommend a bit of research on the local customs or laws about the oaths and affirmations. That's an obligation in the civil courts, but I would also recommend doing it in the Employment Tribunal, particularly so for companies who, for their employees who may be giving evidence, will want to ensure that they're not putting their employees in a difficult position where they may be doing something unlawful in the state that they are based in. Well, that covers the update on video conferencing, and I hope that has been helpful. There is a link in the description below, which will list some of the sources that have been used in this talk. But thank you for your time today, and please tune in for the next 2TG Employment Monthly next month. Thank you.